Welcome to the Ceremon Valley Democratic Club. My name is Brody Hill. I serve as president. Rick Adler, our vice president, is here and will be conducting most of the meeting. Our board member, Cecilia Manalga, is here as our Zoom administrator. There are problems in our world, but for the next week, we need to also be focused on our local June 7th election. Please know that although it is a primary for state level candidates, it is the only election for our county candidates. So the election for our county candidates is by June 7th. Our endorsing candidates are Dinah Becton for district attorney. Our club contributed $1,500 to her campaign. We have endorsed Ben Terrio for sheriff and contributed $1,500 to his campaign. Our other two endorsed candidates are Floyd Andrews for county assessor. She's running against the incumbent Gus Kramer. We also have Sally Lieber, who is running for the Board of Equalization, District 2. For the past 5 weeks, our club has had 16 volunteers put door hangers on the homes of Democrats in Danville, Alamo, and Ceremon. The door hangers, as you can sort of see, list all the endorsed Democratic candidates. Some of our volunteers have completed giving out their allotment of 100 door hangers. Some of our volunteers have delivered even more, and they're going to continue until the June 7th election. And you can help too by canvassing. There's no need to speak to people. You merely just hang the door hanger on the doors of the homes of Democrats in your area. So email us to sign up. Look in chat for our email address, president@srvdems.org. I was going to begin the meeting by stating that May is the mental health month. And that's important too, but with a devastating shooting in Uvalde, Texas, my focus shifted. Right now, I'm sure all of you are, as I am, outraged for President Biden, who said, "Where in God's name is our backbone to stand up to lobbyists?" Congressman Eric Swalwell, "I wish I could look at my 3 small kids and promise I'll always protect them. That would be a lie." Excuse me. America arms the most dangerous people to the teeth, leaving every child vulnerable to being shot in their class. This is not a policy defect. It is by GOP design. Even Steve Kerr, the coach of the Golden State Warriors, said, "When are we going to do something?" He slammed his fist on the table. "I'm tired of offering condolences to devastated families. There's a reason why they won't vote on it," Kerr said. "They want to hold on to power." And he looked into the camera and he asked, "Mitch McConnell, I ask you and Senate and all the senators who refuse to do anything about the violence and school shootings and supermarket shootings, I ask you, are you going to put your own desire for power ahead of the lives of children and our elderly and our churchgoers? Because that's what it looks like." So what legislation was Steve Kerr referring to when he challenged McConnell to call for a vote? It is H.R. 8, the Bipartisan Backgrounds Check Act of 2021. It was written by our Congressman Mike Thompson and has been many co-sponsors, including Congressman Mark DeSaulnier and our Congressman Eric Swalwell. This bill establishes the rules for background checks for firearm transfers between private parties because they're unlicensed. So there has to be special rules. But the GOP doesn't want it. And it's just a background check. The House passed it in March 11th, 2021, and it's currently in the Senate. The GOP won't vote on this simple common sense bill. But we'll save further discussion of gun laws for a future SRVDC meeting. Besides a lack of gun laws, we have the dilemma of a right to abortion. Our democracy seems to be chipped away right before our eyes. We are outraged that the right to an abortion might be taken away by the Supreme Court. And as we experience that outrage, we will educate ourselves about abortion and the law so we may be better equipped to fight back. Roe versus Wade was passed in 1973. I'm old enough to remember living in the state of Georgia in 1971, where abortion was banned. I remember when my girlfriends needed an abortion. She had been using birth control, which failed. Where could she get an abortion? In Atlanta? No. Georgia? No. Thank goodness for Planned Parenthood. They took care of almost everything. All she had to do was buy a round trip ticket to New York City. A well-dressed lady met her at the New York airport and escorted her to her driver, who drove her to a very nice medical facility on Long Island, where she had an abortion. And then she returned to Atlanta that same day. Thank goodness for Planned Parenthood. Remember them in your donation giving. But I give you this example because that's what we as a nation might be going back to, having to go to another state to get an abortion, not in California, but in the other states. Actually, it might even be worse, as some red state legislators have outlawed crossing state lines to obtain an abortion. Tonight, we have our Assembly member, Rebecca Bauer-Kahan. We had planned that she'd speak first, but I was notified that she might be in the Assembly voting on a huge amount of last-minute legislation. So we're honored to have our first speaker, Dr. Radhika Rao, and I hope I pronounced that correctly, a professor at UC Hastings School of Law. Dr. Rao was born in India, moved to the US when she was 1, grew up in Massachusetts. She attended Harvard College. She studied physics and chemistry. After spending a year working for a securities firm in Tokyo, she decided to abandon science for a career in law. She graduated magna cum laude from Harvard Law School. After Harvard Law School, she clerked for Justices Harry Blackmun and Thurgood Marshall of the United States Supreme Court. She will give the PowerPoint presentation on abortion and the law that she will give next week to the American Society of Law, Medicine, and Ethics. And it turns out that physicians are interested in abortion also, and in the law. Why? Because they want to know things like, if I prescribe pills that are against the law to a person in a state where the abortion pills are against the law, does the Constitution guarantee my right to do that? That is the reason last week she gave the presentation to the physicians at the Zuckerberg San Francisco General Hospital. We get to see the same presentation at our meeting tonight. Thank you, Professor Rao, for being here.
Thank you so much for that wonderful introduction. And actually, you will need to make me a co-host so I can share my slides, because I just tried doing that.
Oh yeah, I'm sorry, yes.
But I think it was disabled.
There.
Okay, so I'm a co-host now. Okay, so let's see. Excellent. Here is my PowerPoint presentation. So are you able to see my screen? Yes? And just one small tiny correction, which is I did give a presentation, but not to Zuckerberg General Hospital, actually to UCSF Medical School. So similar, but not exactly the same thing. They have something called grand rounds, where you speak to all of the physicians and staff and people at UCSF Medical School. And so I was invited by Dr. Bob Wachter. Some of you may have been following him. He's become a very big guy in the news lately because they're always interviewing him about COVID. So anyway, he interviewed me last week at UCSF Medical School, and I am giving, as Brody said, the exact same presentation that I gave them last week. I decided that it worked well for a general medical audience, so I think it should work well for all of you as well.
Dr. Rao, could you start the PowerPoint so the slide will be bigger on our screen? Or not?
Yes, I'll do it in the slideshow mode.
Thank you.
So there, you see it? So this presentation is called Roe, Dobbs, and the Future of Reproductive Rights and Justice. And it tells you who I am. As Brody tells you, I'm a professor of law and a Harry and Lillian Hastings Research Chair at the University of California, Hastings College of the Law. So I'm starting off just by giving you the provisions of the 14th Amendment to the Constitution, which are the provisions that have governed in this situation. And specifically, there are two parts of the 14th Amendment: the Due Process Clause and the Equal Protection Clause, which have been invoked in cases involving the right to terminate pregnancy, the right to an abortion. The Due Process Clause says that no state can deprive any person of their life, liberty, or property without due process of law. And that has been interpreted to include not only fair procedures, but substantive rights as well. And then the Equal Protection Clause says that no state can deny to any person within its jurisdiction equal protection of the laws. So these are the constitutional provisions that I'll be referring to today. But I thought I would start off by describing for you, before I talk about the leaked opinion and the latest case, the background to this is, of course, Roe versus Wade in 1973. So as Brody said, before Roe versus Wade in 1973, there was no constitutional right to terminate pregnancy, to have an abortion. But in Roe versus Wade, the court confronted this issue, the Supreme Court confronted this issue for the first time. And by the way, that's a picture of Justice Harry Blackmun, for whom I worked at the US Supreme Court. And I've got that picture up because he was the author of Roe versus Wade. So the opinion that pronounced a constitutional right to an abortion. What happened in Roe versus Wade? Well, it was a case coming out of Texas. Texas, which is very much always in the news, including this past week. But Texas had a law that made procuring an abortion a crime, except by medical advice for the purpose of saving the life of the mother. So unless the woman's life was at stake, she could not have an abortion. It was illegal in Texas. And the Supreme Court said that this law was unconstitutional. They relied upon an unenumerated right to privacy that's grounded in the Due Process Clause of the 14th Amendment. And what do I mean when I say unenumerated right? Well, the Constitution, this document that I've got here, nowhere mentions the word privacy. It doesn't explicitly protect any right to privacy. But the Supreme Court held that the 14th Amendment, the Due Process Clause, contains this unenumerated right. And here's the language of the court's opinion in Roe. Quote, the Constitution does not explicitly mention any right of privacy, but the court has recognized that a right of personal privacy or a guarantee of certain areas or zones of privacy exist under the Constitution. And then the opinion continued. This right of privacy, whether it be founded in the 14th Amendment's concept of personal liberty, as we feel it is, or in the 9th Amendment, that's another constitutional provision, this right of privacy is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. That's the language of the court's opinion in Roe versus Wade in 1973. Before I get to the framework which the court articulated in Roe versus Wade, I should give you a little bit of background about Mr. Justice Harry Blackmun, the man whom I worked for, who authored the opinion in Roe. Before Justice Blackmun was appointed to the US Supreme Court, and by the way, Justice Harry Blackmun was a Republican. Before he was appointed to the Supreme Court, he was appointed by President Richard Nixon. So he was not considered to be, this liberal icon that today he is kind of held out to be. At the time that he was appointed to the court, he was viewed as a Republican. But I think the Republican Party back then was really a very different kind of a Republican Party than it is today. And you'd never see Justice Blackmun is a rarity, unheard of in today's climate. But anyway, before he was appointed to the US Supreme Court, as I said, he was a Republican. But not only was he that, he actually was the chief legal counsel for the Mayo Clinic, the medical clinic, one of the most eminent medical institutions in the United States, in Rochester, Minnesota. He was the lawyer for all of those physicians. And so he really understood about doctors and the practice of medicine before he even became a judge. And so when Roe versus Wade came before the US Supreme Court, I'm telling you now some background history that is not widely known. At the time that Roe came before the US Supreme Court, that first year that Justice Harry Blackmun was appointed to the court, there were two justices on the court, Justices Harlan and Justice Black, who were very old, and they suddenly retired for reasons of bad health, and later they died. So the court was short of two justices. Instead of the full court of 9 justices, they had only 7 justices on the court. So Chief Justice Warren Burger, who was Chief Justice at the time, appointed what he thought to be a screening committee. He didn't want a court with only 7 justices to take cases that would be controversial, because if you decided a case with 7 justices, it could be decided by a majority vote of 4-3. But if you had 2 more justices appointed to the court, it could go 5-4 the other way. So he established a screening committee. And the purpose of this screening committee was to choose only cases with this short court that were non-controversial. And Justice Blackmun told me that he was one of the members of this screening committee. And he said that there were a couple of other justices assigned to the committee too. And he said one of the non-controversial cases that they selected for the Supreme Court to hear that term was Roe versus Wade. So it gives you a sense of how different the political climate at that time was. They didn't realize that abortion was going to be this incredibly controversial issue that would plague the court for the next 50 years, for the next half century. Justice Blackmun kind of sheepishly said to me, I didn't do a very good job on that screening committee because one of the cases that we selected was Roe versus Wade. So anyway, they heard the case. They first heard the case in 1972, but Justice Blackmun was assigned the task after the oral argument of writing a memo in the case. And he recommended that the case should not be decided because there were only 7 justices on the court at the time. He said, this issue is too important to be resolved by a court of only 7 justices. We should hold the case over. We should wait for the court, for the remaining justices that were going to be appointed by Nixon to be appointed, and we should re-argue the case and decide it the following year. And he said that some of the more liberal justices who were worried that the new justices that Nixon was going to appoint, the case would come out differently. They were worried that the abortion law would be upheld, the law prohibiting abortion. But Justice Blackmun said sounder minds prevailed, and they held the case over for re-argument the following year. And he went that summer, he went back. It was the summer after his first year as a Supreme Court justice. He went back to Rochester, Minnesota, to the Mayo Clinic in Minnesota, and he holed himself up in the library. And the whole summer, all he did was research the issue of abortion. He read every medical textbook. He read the Hippocratic Oath. He read about viability and trimesters and all of this medical terminology, because he suspected that he would be the person who would be assigned to write the opinion in Roe versus Wade the following year. Why? Because he had written the memo the previous year, and he'd recommended that the law be struck down as unconstitutional. But he also recommended that the court rehear the case and hold it over for argument the next year. And also, he was a childhood friend of Chief Justice Warren Burger. So he believed that Burger would have assigned the opinion to him. So, and he was right. So he went and he spent the entire summer doing research. And ultimately the case was re-argued the following year, but they came out with the same result. There were 2 new justices who were appointed in the interim. The 2 new justices that Nixon appointed were Justice Lewis Powell and Chief Justice William Rehnquist. Rehnquist voted the other way. But Powell went along with Justice Blackmun and the others to strike down the abortion law. So the court voted in Roe versus Wade. They voted 7 justices to 2. There were only 2 justices in the dissent in Roe versus Wade. And by the way, one of those justices was actually a Democrat. Byron White was one of the dissenters in Roe versus Wade, and the other dissenter was William Rehnquist. So all of the other justices thought that there was, in fact, a constitutional right to privacy, that there was a constitutional right to an abortion, including many justices that had been appointed by Republican presidents. So it was not so political then as it is today. So that's the background that I'm telling you, the little known background. But here's Justice Blackmun's opinion in Roe versus Wade. So in Roe versus Wade, all of that medical expertise that he had came in. And essentially what Justice Blackmun's opinion did was not only say that there's a constitutional right to an abortion, but he set forth a framework for constitutionality that was largely based upon a medical framework. The medical framework here was dividing the 9 months of pregnancy into 3 trimesters. The court ruled, Justice Blackmun's opinion for the court ruled, that in the first trimester, the government, the state, shouldn't even be able to regulate abortion, largely because the risks of abortion are far less than those of childbirth. So there really isn't any government interest in regulation. In the second trimester, the court ruled that the government's interest in protecting the health of the mother, the woman, becomes compelling. So that at that point, and what we're talking about here is after 3 months of pregnancy, the interest in the state in protecting health becomes compelling. So that the government can regulate abortion procedures, but only to advance the health of the pregnant person. In the third trimester, so we're talking here after about 6 months, the government's interest in protecting the potential life of the fetus becomes compelling. So at that point, the government can prohibit abortion, except if it's necessary to the woman's life or necessary to her health. And here they meant health very broadly speaking, not only including physical risks, but also mental health as well. So that if there would be any health interest in a woman in terminating her pregnancy, that should prevail even in the third trimester. So that's the framework that the court set forth in Roe versus Wade. But the really important thing about Roe was that the court drew this critical line at viability. And what is viability? Viability was defined as the point at which the fetus would have the capability, the capacity for survival outside the womb. And at the time of Roe, that was roughly 24 to 28 weeks of pregnancy. But with advances in medical technology since 1973, it's about 20 to 24 weeks now. The earliest point at which a fetus can survive would be, even with the best medical technology, no earlier than 20 weeks. And you can see on my graph over there, viability really is a kind of a survival chart. So the survival rate you can see at about, it really plummets if we're talking about before 22 weeks. Why draw this line at viability? Well, according to Justice Blackmun's opinion for the court in Roe, which was the majority opinion, the viability line has, quote, both logical and biological justifications. What are these justifications? I think that you can really categorize them as in 3 different categories. One set of justifications is philosophical. Philosophically, viability marks the earliest point at which the fetus has the capacity to survive outside the body of another person. So philosophically, prior to viability, it cannot live except inside the womb. But at viability, it has the capacity to live in an incubator to survive. So you could think about that as being the earliest point at which you can consider it to be an entity, a distinct entity with the possibility of rights of its own, independent of somebody else. Prior to viability, it's like a parasite. It basically has no ability to survive except inside another person's body. So that's the philosophical justification. What about the medical justification? Well, viability also marks a stage of higher development. And so, an embryo, a couple of days or a couple of weeks is really just a clump of cells. But as it progresses through the pregnancy, you can think that it gains significance. And some of the earliest markers of what we might think to be philosophically significant lines as well. So things like the formation of the earliest possibility of the spinal cord, which might ultimately lead to higher development. And finally, what are the legal justifications? Well, remarkably, the viability line not only coincides with these philosophical and medical justifications, but at the common law that existed at the time that the Constitution was framed, there was, and Justice Blackmun looked into this jurisprudence, women who terminated their pregnancies, who had an abortion prior to viability, that was never criminalized. It was only later, at the time of the adoption of the 14th Amendment, that the medical profession started regulating abortion. But at the time that the Constitution was framed, prior to viability, and actually they called the line quickening. Prior to quickening, which roughly coincides with viability, abortion was not a criminal offense. So Justice Blackmun articulated these kind of different justifications for the viability line and suggested that that's the critical line, that prior to viability, a pregnant person should have the right to terminate their pregnancy. But after viability, the rights of the fetus could be considered, and a state, if it chose to do so, could prohibit abortion except when the woman's life or health was at stake. So that's the key line that Roe drew at viability. But what about fetal personhood? Today, we hear a lot about fetal personhood, and many states have enacted laws that purport to grant personhood to the fetus. Of course, if you grant personhood to the fetus, the more that you treat the fetus as a person, the less that you treat the person who carries that potential person as a person, because their rights give way. So what about fetal personhood? Roe actually said some things about fetal personhood. In Roe, the Supreme Court ruled that a fetus is not a, quote, person protected by the Constitution. Here I have a little bit of background information to give you as well, by the way. That language, that the fetus is not a person, was not part of Justice Blackmun's original draft opinion in Roe versus Wade. When he drafted his opinion, he did not want to answer the question whether a fetus is a person. But he sent around the draft to the other Supreme Court justices. And one of the other justices, Justice Potter Stewart, actually, said to Justice Blackmun, you need to say that the fetus is not a person. And if you don't, I'm not going to join your opinion. I'm going to write separately. And Justice Blackmun wanted to have as unanimous an opinion as he could, because that helps to give the opinion legitimacy. You want to get as many other justices to sign on to your opinion. So he added the language that the fetus was not a person. And that's some of the most inflammatory language of Roe versus Wade, was this language that the fetus was not a constitutional person. Justice Blackmun told me it wasn't in the original draft opinion, but he added it in response to Potter Stewart's suggestion, or essentially demand, that he added in order to have as unanimous an opinion as possible. And he's really been criticized. Justice Blackmun's opinion in Roe, it's been criticized on many fronts, but one of the things that's been most criticized is this ruling that the fetus was not a constitutional person. In fact, Many scholars and judges and others have argued that the Supreme Court should not have answered that question. And they also have argued that it would have been better for the court to ground the right to abortion, not in the Due Process Clause of the 14th Amendment, but in the Equal Protection Clause. Who were some of these critics of Roe versus Wade? One of them was Justice RBG, the famous Ruth Bader Ginsburg. She argued that it's not that she didn't believe in the right to an abortion. She did, but she argued that it would have been better for the court to frame the right as a right that's part of the Equal Protection Clause, not the Due Process Clause, because abortion is very much necessary to ensure gender equality, equality for women, equal citizenship under the Constitution. Another, Professor Catherine McKinnon, labeled by some a radical feminist, also has argued that the Roe right, that Roe was wrong because it framed the right to abortion as part of this right to privacy. But she suggested that the right to privacy framing reinforces the inequality in the private sphere. However, and this was Justice Blackmun, he said this to me. He said the equal protection theory was not argued to the Supreme Court in Roe versus Wade, nor would it have been successful at that time. Because at the time that Roe versus Wade was decided, first of all, equal protection based upon gender wasn't even recognized under the Constitution. It wasn't recognized until 3 years after Roe versus Wade that gender equality is protected under the Constitution. Can you imagine that? But that's what the state of the law was at the time of Roe versus Wade. Moreover, 1 year after Roe versus Wade, the Supreme Court decided this case that I've got here called Geduldig against Ayala. It was a California case, actually, involving a California law, a disability law, that provided coverage for a wide number of, provided for health coverage for a number of disabilities, but they excluded specifically pregnancy. So this was challenged as unconstitutional, as a violation, as discrimination against women, because only women get pregnant. So to exclude pregnancy while providing coverage for all these other kinds of health reasons that men are subject to, the argument was gender discrimination. The Supreme Court, 1 year after Roe in Geduldig, said that pregnancy discrimination is not sex discrimination. That's what they held. Why? Because it draws a line between pregnant women, they said, and non-pregnant persons. They said the former category includes only women, but non-pregnant persons includes women as well as men. So they said pregnancy discrimination is not the same thing as gender discrimination or sex discrimination, because not all women become pregnant. Yeah, it took Congress to reverse that decision. A year later, they enacted the Pregnancy Discrimination Act, which said pregnancy discrimination, Congress believe, does in fact constitute sex discrimination. But that only reversed the decision of Geduldig as a statutory matter. It didn't reverse it constitutionally. And by the way, even Justice Scalia very recently has said that he thinks the Constitution says nothing about sex or gender equality. It doesn't protect it, because that's not what the framers of the Constitution intended or the 14th Amendment. When they enacted the 14th Amendment's Equal Protection Clause, they didn't mean to include women. So that brings us to the more recent Supreme Court decision in Planned Parenthood against Casey. In 1992, 30 years after Roe versus Wade, the Supreme Court came very close to overruling Roe back then, 30 years ago. But at the last minute, and here I'm telling you some kind of secret background history, at the last minute, one justice switched his vote. Who was it? Justice Anthony Kennedy, right there, the guy with the red tie and the glasses in the middle. He joined with Justice Sandra Day O'Connor and Justice David Souter. And these three Republican appointed justices retained and reaffirmed what they called the essential holding of Roe versus Wade. They said that the essential holding of Roe was the viability line. And so they said that should be adhered to. But they struck down what they thought was not the essential holding of Roe. And what is that? The trimester framework. They got rid of the Roe's trimester framework that I just described to you, and instead they replaced it with a new constitutional standard, the undue burden standard, which is much less protective of the right to abortion than Roe versus Wade was. But it still protects a little bit of an abortion right, but not as stringently as the trimester framework did. Under the new undue burden test, they would strike down or invalidate only those laws that have the purpose or effect of imposing a substantial obstacle in the path of a woman seeking an abortion prior to fetal viability. If it wasn't a substantial obstacle, it was constitutional. Because they got rid of the Roe trimester framework, they replaced it with the undue burden standard. That's what happened already 30 years ago. In Casey, the Supreme Court, under this new undue burden test, they upheld an informed consent requirement that required women seeking an abortion to be told of the nature of the abortion procedure, the health risks of abortion and childbirth, the probable gestational age of the fetus, and to be given a whole bunch of information regarding childbirth assistance, child support, and adoption. They also upheld a 24-hour waiting period that required women seeking an abortion to get all this information and then go home and wait for 24 hours before, and only then can they come back and have an abortion. The Supreme Court said that requiring the provision of truthful, non-misleading information does not constitute an undue burden, nor does the imposition of a 24-hour waiting period. Now, by the way, Justice Blackmun dissented from this part of Casey. He thought the 24-hour waiting period was unconstitutional. He also would have struck down the informed consent requirement because it was giving all of this information very paternalistically in order to persuade women not to have an abortion. It was too directive. But the plurality, those three, they upheld it. And since you didn't have enough votes to go with all of Roe versus Wade, Casey became the law of the land. But they struck down, the only thing that they thought was unconstitutional was a spousal notification provision, which required a married woman seeking an abortion to sign a statement indicating that she had told her husband. And the only exceptions to this requirement were if the husband was not the father of the fetus, and that would have to appear from the birth certificate, or if the pregnancy was the result of a reported spousal sexual assault. She would have had to call the police. Then she didn't have to tell her husband if she called the police and said he raped her. Or if the woman said that notifying her husband would cause him to inflict bodily injury upon her, then she didn't have to tell her. But if she thought that notifying him would cause him to inflict psychological injury on her, economic injury on her, or bodily injury upon her children, no exception. She'd still have to tell her. The court thought that law was unconstitutional. That's the only one. And by the way, the penalty for a physician who performed an abortion on a married woman without the appropriate signed statement, the physician, the doctor, could lose his or her medical license and or be liable to the husband for damages. That was a pretty drastic law. That's the only one that the court struck down in Casey. The remaining provisions were upheld. So that was Planned Parenthood against Casey, which was the law of the land until now. Now, that brings me to the current moment and the leaked SCOTUS opinion in Dobbs against Jackson Women's Health. The draft opinion by Alito overturning Roe versus Wade. First question, cui bono? Who stands to gain from the leak? Who leaked it? Everybody's been asking these questions. And there's really good speculation on all sides. You know, some people leap to the conclusion that it must have been a liberal clerk, a law clerk for one of the liberal justices or a liberal court employee. That is a possibility because you can imagine somebody who's so outraged by this horrendous opinion that they believe that the public has a right to know before the court comes out with it. But I actually think the more plausible explanation is that it was a conservative, either a clerk for a conservative justice, or perhaps even, dare I say it, Ginny Thomas. There's been some speculation actually about Ginny Thomas perhaps having leaked it. Now, what would be the motivation? Here's the motivation. Look at the current Supreme Court. I've got circled in red the conservative, the right-wing justices, right? Justice Clarence Thomas, Justice Alito, who drafted this opinion, Justice Brett Kavanaugh over there on the left, and then Neil Gorsuch and Amy Coney Barrett on the right. Those are the 5 justices who were part of the majority in the Dobbs leaked draft opinion. The fear is that the conservatives, what they're worried about is that what happened before at the time of Planned Parenthood against Casey could happen again. What if one justice flips his vote? So the motivation for a conservative to leak it could be that they want to solidify that conservative majority. They want to leak it so that Kavanaugh, he's the most likely to flip his vote, and he actually is the replacement for his former boss, Anthony Kennedy, to prevent Kavanaugh from flipping, or perhaps, I think it's less likely, Amy Coney Barrett. The explanation is that perhaps a conservative leaked the opinion to kind of reveal that they'd already voted this way, so that they would feel embarrassed to flip their vote and change their vote at the last minute. So I've got in red the conservative justices. Circled in blue are the libs, right? The liberal justices. Justice Elena Kagan, appointed by Barack Obama, Justice Stephen Breyer, an old Clinton appointment, and Justice Sonia Sotomayor, also appointed by Obama. And then in the middle in purple, because he's really quite conservative, but in some ways tries to portray himself as more of a moderate, middle of the road kind of a guy, Chief Justice Roberts. And really, I think it's because he doesn't want his court to look so illegitimate. So he doesn't want to overrule Roe too quickly, because it's barely been, 2 years since Amy Coney Barrett replaced RBG, and already the court's getting rid of Roe versus Wade. So the argument is that Chief Justice Roberts is trying to assemble a more moderate majority that he could join with the 3 liberals, and if he could get one more justice to defect, then they could retain and reaffirm Roe versus Wade. That might be the motivation for a leak. So that's a little bit about the leak. And here are my ideological scores of the justices, but I'm going to skip this slide to say, ultimately, what does the draft opinion say? It's a horrible opinion, a horrendous opinion. For those of you who've read it, it says some really awful things about Roe versus Wade. It skewers really Roe versus Wade, and it's gratuitously insulting of the opinion that Justice Harry Blackmun, my old boss, wrote in Roe versus Wade. It's really insulting of Roe and of the reasoning behind it. Here are some quotes from the opinion. Quote, Roe's survey of history, Justice Alito's draft opinion says, ranged from the constitutionally irrelevant, e.g. its discussion of abortion in antiquity, to the plainly incorrect, e.g. its assertion that abortion was probably never a crime under the common law. After cataloging a wealth of other information having no bearing on the meaning of the Constitution, the opinion concluded with a numbered set of rules, much like those that might be found in a statute enacted by a legislature. That is so harsh and so caustic, so insulting of Roe. And I think so wrong too. All of that information that Justice Blackmun spent the summer researching about medical information and historical information about abortion, he just belittles it Alito does in this draft opinion. What else does he say? Quote, Roe was remarkably loose in its treatment of the constitutional text. It held that the abortion right, which is not mentioned in the Constitution, is part of a right to privacy, which is also not mentioned in the Constitution. And then he says, Roe expressed the feeling that the 14th Amendment was the provision that did the work. But its message seemed to be that the abortion right could be found somewhere in the Constitution, and that specifying its exact location was not of paramount importance. Do you see how insulting, how mocking, how ridiculing this language is? It's very harsh, and it's very atypical of a majority opinion. In general, a majority opinion that's authored by a Supreme Court justice is written in a much more balanced, neutral fashion, with some respect for precedent. But this opinion has absolutely no respect. He's just totally mocking Roe and everything about it. But substantively, beyond the tone of the opinion and the ridiculing of Roe, what does the draft opinion actually do? Here's some more language. Here's what it says. Quote, we hold that Roe and Casey, the two cases I just described for you, must be overruled. Why? The Constitution makes no reference to abortion, and no such right is implicitly protected by any constitutional provision, including the one on which the defenders of Roe and Casey now chiefly rely, the Due Process Clause of the 14th Amendment. That provision has been held to guarantee some rights that are not mentioned in the Constitution. But any such right must be deeply rooted in this nation's history and tradition and implicit in the concept of ordered liberty. What else does the opinion say? Quote, it is time to heed the Constitution and return the issue of abortion to the people's elected representatives. The permissibility of abortion and the limitations upon it are to be resolved, like most important questions in our democracy, by citizens trying to persuade one another and then voting. That is what the Constitution and the rule of law demand. So that's the actual outcome. What is he saying? What does the draft opinion do? It would result in this: a patchwork of state laws in the 50 states. I've got in blue the states where abortion will be still legal. It'll continue to be legal after Roe versus Wade. In red, dark red, are the states where abortion is going to be completely prohibited. And then lighter red are where it's going to be very much restricted, and gray, we're not yet sure what might happen in some of those states. So here's a map. This one is taken from The Economist, of the outcome, what it's going to look like if and when Roe versus Wade is overturned. And here it is. Sorry, I skipped this slide. If the US Supreme Court overturns or guts Roe versus Wade, this is a map taken from the Guttmacher Institute. Very great source of information on all kinds of, abortion, family planning. 26 states, Guttmacher predicts, are certain or likely to ban abortion. And here it is, the 26 states where abortion will likely be illegal. And then I showed you the patchwork of state laws. What else is important about the draft opinion? Well, what does it portend for the future? Justice Alito attempts to distinguish abortion from all of those other rights that also are not explicitly enumerated in the text of the Constitution. Here's what he says. Roe's defenders characterize the abortion right as similar to rights recognized in past decisions involving matters such as intimate sexual relations, contraception, and marriage. But abortion is fundamentally different, as both Roe and Casey acknowledge, because it destroys what those decisions called fetal life, and what the law now before us, the Mississippi law at issue in Dobbs, describes as, quote, an unborn human being. So basically, what is he saying? He's saying, we're just talking about abortion. We're not talking about those other things that are also not explicitly mentioned. They're also not protected in the text of the Constitution. However, the logic of the draft opinion cannot be cabined. It cannot be confined to abortion. The same logic that he gave you for why abortion is not protected, because it's not explicitly enumerated in the text of the Constitution, because it's not deeply rooted in history tradition, that same logic also applies to contraception, at least those methods of contraception that apply post-fertilization to prevent implantation of the embryo. But it goes even further. Contraception is also nowhere mentioned in the text of the Constitution. And the contraception cases are not much older than Roe versus Wade. And what about the other rights that aren't explicitly mentioned in the text of the Constitution or deeply rooted in history and tradition, such as the right to marriage equality, to same-sex marriage? That's a much more recent right than Roe versus Wade. Roe versus Wade is almost 50 years old. It was decided in 1973. But Obergefell was decided only about 5 or 7 years ago, I think, 2016, 2015. So Obergefell, the case involving the right to same-sex marriage, that might be overruled too. And that concludes my rather ominous, scary presentation on Roe, Dobbs, and the future, what the future may hold. I'm sorry if it's dark and depressing, but that's the truth, right? So that's kind of where we are right now. It is possible that that draft opinion will not ultimately be the majority opinion. It is possible that Chief Justice Roberts will get somebody, most likely would be Justice Kavanaugh, to flip this vote, but I think it's less likely now after the leak, because everybody knows what he originally voted. So the leak may in fact do what I think the conservative leaker would intend, which is to freeze that Alito draft and make it the majority. So that's my prediction. We'll see what happens. And yeah, so I open it up for questions and or comments.
Thank you so much. I think you really overwhelmed us. That was so interesting with all the information and your little secrets that you got to tell us. So yes, we'll open it up for questions.
Well, I have one. You mentioned at the very beginning about, or someone mentioned at least, about physicians who perform abortions for women from out of state and what might happen to them. And is there any, is there any consensus on the problems those physicians might have?
So I think currently, under current law, it looks like that they should not be held liable, I think. But it's not clear. Unfortunately, I think the contours of the current law are not very clear on this. So think about it this way. If a physician from another state participated in a murder, you might want to hold them liable. So if one state, say Texas, is saying that abortion is murder, and if you have a physician in another state who's prescribing a drug for a person in Texas to kill another person, and Texas says they're an accessory to the murder that happened in our state, if it were actual murder of a person, we probably would think that you could have a criminal prosecution, right? That they could be held as an accessory to that crime. Now, the reason I think it's different is I don't think the fetus is a person, and I don't think that it's murder. But for the state of Texas to punish murder within its state, and to punish somebody who's an accessory to that murder, who prescribes the drug that allows the murder to take place, the poison in state, it's not an easy question, I think. It's not totally clear. Now, if you go out of state to the state where abortion is legal, and you then have the abortion in the state where it's legal, under current law, that should probably be protected. But even that, the red states are trying to crack down on. They're trying to prevent pregnant people from traveling from their state to another state to have an abortion. And they're saying that if they do, it's like kidnapping with the intent to murder. So it's just absolutely crazy, these laws, what the laws that are being enacted in the red states. And although under current precedent, we think that there's a constitutional right to travel from one state to another, that right is also unenumerated. It's not explicitly mentioned in the text of the Constitution. So the same conservative court that says that abortion is not a right could say that travel isn't a right either. So it's pretty frightening. I see a hand up. Is it Ellis and Sharon Goldberg?
It's Ellis.
The main argument, the way I see it, and I think I'm a bit older than you, because I remember back alley abortions, coat hanger abortions, women dying under just horrible, horrible conditions. And it seems that in all of these arguments, the Supreme Court is sitting up on Mount Olympus and they don't see anything like that. And I don't hear in any of these arguments, if we make abortion illegal, we're going to only have illegal abortions. We're not going to stop abortions. And it seems to be that's the overriding issue. If you make abortion illegal, you will have people dying, women dying unnecessarily under horrible conditions. And
I totally agree with you.
the Supreme Court will even take that into account. They just seem to be playing this like a game of chess rather than a life and death situation.
I totally agree with you. And Justice Blackmun agreed with you, by the way, as did Justice Thurgood Marshall. I mean, my heroes, the justices that I worked for, they understood the impact on real lives and real people. They had humanity. But this court that we have, they don't see it or they don't care. I don't know what it is, which. But these justices, as you said, they live in an ivory tower up on Mount Olympus. They don't seem to have empathy for the average person. Now, Justice Harry Blackmun, I can tell you, he actually subscribed to a prison newspaper because he wanted to know what it was like for people who were in jail. He read that newspaper and he got so much hate mail for writing the abortion opinion, like 70,000, 80,000 letters. He read every single one because he cared what people thought. He wanted to know about the real world. But these justices today, some of them, they lack empathy. It seems they don't really care. I cannot understand where they're coming from and why they are that way, but they really do not seem to care or know about the average person. Yeah. So I see some other hands up. Chris and Stephanie Tadeo.
First of all, thank you so much for the presentation. It was really amazing. We both were just learning so much.
You're welcome.
I have two questions. So I hope I can pose both of them. The first one is, I can't help but think then, so did these various justices lie when they were going through the Senate approval process? Because they've all been asked, how do you stand on Roe v. Wade or Casey or whatever? And we always heard, well, we're not gonna change, precedent law, settled law. and what's there is there. And then my other question is, do you have any thoughts about how much this is supported by people in the red states? Is it a little bit like the gun legislation where it's a minority that just has this outsized voice? I mean, because I feel like I read articles and it's a high percentage of Americans that approve of abortion. So how is this being carried over in 26 states? So
Wow, great questions. On the first one about the justices lying under oath, my dad is a lifelong Democrat, and he just is so furious. And he says, impeach them. I mean, they lied, but he also understands that it's sophistry, right? So what did they say? They were very careful. They said, Roe versus Wade is settled law. Now, what does that mean? It's settled until we get up on the Supreme Court and unsettle it. So yes, when they were lower court judges, when they were legislators, they had to abide by precedent. But when you're on the Supreme Court, what's settled can become unsettled. And those senators who listen to those justices, those prospective candidates for office say it's settled law and quote, believe them, they were idiots. I was furious at Susan Collins and the rest of them then. And I mean, they were idiots, right? They believed them. I knew, everybody knew that as soon as they got into a position where they could vote to change the rules, they would. And if you didn't know that, then you didn't know how politics works and how precedent works. Because yes, it was settled law, but if you don't have respect for precedent and you appoint people who have sworn that they're against it, and if you read their opinions when they were lower court judges, even then they purported to apply Roe and Casey, but they stretched it to the limits. And they really showed disrespect for it, even as lower court judges and even as academics. Amy Coney Barrett as an academic, Brett Kavanaugh as a judge. I read his opinions. It was clear where these people stood. So on the precedent question, yes, it's settled until it's unsettled. And when you're a Supreme Court justice, and what's their excuse now? They said it was wrong. It was a wrong precedent. Just as Plessy versus Ferguson was wrong, as separate but equal was wrong. And we, just like the Supreme Court was right to get rid of Plessy, separate but equal, and to say that integration is required by the Constitution, that segregation is unconstitutional, we are doing a great thing. That's what Alito says in his draft opinion. We are doing the equivalent of Brown versus Board of Education. Roe was like Plessy, and Dobbs is like Brown versus Board of Education. And if it was a wrong precedent, then we are doing a great thing in getting rid of it. So that's their response to settled law. Now, on the other issue of the politics and the red states, I do not understand how poor people who are the ones who are going to be bearing the brunt of these laws could vote for the politicians who would enact such disingenuous laws. But I don't understand how those people whose children are dying of gun violence could vote for Trump and the legislators that refuse to enact laws that would protect them. So I really don't understand how people can be so ignorant. I mean, it boggles my mind, right? I was just talking about that with my dad, and he says that he read Arlie Hochschild's book. So read Arlie Hochschild, where she talked to the voters in the red states about why it is that they have these opinions. And really, it's complicated, I think, to understand. But she's a great sociologist, Arlie Hochschild. So I guess I would advise you to read Arlie Hochschild's book.
We
Yeah.
had Arlie Hochschild speak to our club meeting about 3 or 4 years ago, and she told us about her book that she wrote. Yes.
Excellent.
Yeah.
So wow, you have had an
Yeah.
amazing, eminent group of speakers. I am so honored and privileged to be one of the people that is speaking to your group. So yes, I really admire her work.
Stephanie, do you have another question real quick?
No, I don't, but Brody,
Okay.
could you just put her, could you put her name in the author and the name of her book in the chat, or Ms. Rao, if you could do that as well, okay. Thank you so much for answering both those questions.
Oh yes, you're welcome. So Arlie, I think this is how you spell it, but I'm not quite sure. Arlie Hochschild?
That's correct. Yeah.
Yes.
Thank
And
you.
so I've got, let's see, Richard Adler. We didn't hear from you yet. So we should go to you and Cynthia before we come back to Ellis Goldberg.
And you have entered the pantheon of great San Ramon Valley speakers, this presentation.
Thank you.
So glad to hear it. I love the knowledge and the passion behind what you say. I've heard that some of the states that want these abortion laws to be in effect have also said that they could penalize somebody from leaving the state and going to another state to get an abortion. You think that is something, I don't know if that's under the Commerce Clause or what, but I don't know how that would be possible. What do you think?
Yes, so I agree with you. Under the Commerce Clause, as well as there's a case called Sands against Roe. I didn't have time for it in my presentation, but it's a Supreme Court case in which Justice Stevens talks about an unenumerated constitutional right to travel, to liberty, to go to another state. And by the way, not many people know this, but there was a companion case to Roe versus Wade called Doe v. Bolton, which involved a Georgia law. Brody was talking about Georgia, that said that you had to be a resident of Georgia in order to be able to get an abortion in Georgia. So in Roe, in the companion case of Doe, the Supreme Court struck down that Georgia law that established a residency requirement. Only Georgia residents could get abortions there. So if you came in from out of state, you couldn't get an abortion in Georgia. So under current precedent, it looks like there should be a constitutional right to travel as part of the Dormant Commerce Clause, as part of this unenumerated right to travel, and durational residency requirements where states say you have to live in the state to get an abortion, or requirements that prohibit you from going out of the state to be able to get an abortion currently seem unconstitutional. However, there is an exception, or there are exceptions. And during the pandemic, some of those exceptions were invoked, where states were saying, we think that it's a medical emergency. So we're going to save abortion services only for people in state because there's too much, there's too many demands on our medical system. Or there are some exceptions. And also, as I said, this right to travel is partly an unenumerated right. So in a court that's so disrespectful of precedent, including Commerce Clause precedent, and including the unenumerated right to travel, it's not clear how long those precedents will stand and what this court will do about it.
Thank you very much.
Yeah, you're welcome. So Cynthia Mahoney, I think we haven't heard from you yet.
Yes, hi. Thanks so much. That was just fascinating background. I really appreciate that. I wanted to mention that this whole movement to prioritizing the life of the fetus over the life of the mother is extremely dangerous. There are medical conditions like ectopic pregnancy that are deadly to the mother. The mother cannot survive without medical treatment, without a medical abortion, spontaneous abortion. And the fetus has no possibility of survival. And yet some of these legislatures are not making an exception for that, which says to me, it's not about life, it's about power and control. And I think it's interesting, I put in the chat a podcast called Majority 54, which is about progressive messaging. And they talk, there's one called Suburban Women Against Extremism. They talk about messaging really to generate empathy, just like many good people are concerned about abortion. You know, nobody wants to see an 8-month-old viable fetus aborted that could be a child. You don't want excesses here, but where is that balance? And there's empathy for the fetus. Where's the empathy for the women? And that we have to start speaking in very graphic terms about specific cases and how damaging they're going to be, so that we restore some kind of balance.
Totally agree with you. And I actually agree with you on the point, both about it's not about empathy or caring about life, and it's about control of women. That's part of it. And really devaluing of women, women's bodies, women's autonomies. Those are, this fetal rights, fetal personhood movement very much comes from that. But I don't even think that these people, many of them, even care about fetuses, really. Because once they're born, they stop caring about them. Because the same red states that have the most restrictive abortion laws, by the way, also provide the least in the way of benefits for families with children. WIC programs, women, infant, and children, care for maternity, child support, health insurance. And by the way, those same states, if they really cared about life, what about the lives of the children in these schools that are gunned down? So it's so awful and hypocritical. Because really, I could respect somebody who truly believed in all life and who truly conscientiously was trying to save life in all of its forms. But these laws, to me, do not come from that place.
Right.
So, Nicole, Sue, is it? Yes.
Yeah, I was just wondering if you have any thoughts on the potential of ever expanding the court.
Oh, wow. Well, I think Biden appointed a commission to study that issue. And actually, the commission really was not in favor of doing that. Now, it's become desperate, really. And many people think that desperate times call for desperate measures. But the problem also is, even if you could agree, we don't have the votes in Congress. I mean, I don't know.
Do you think if we were to, really change the tide in this next election, that it could maybe be something brought to?
Maybe, but they couldn't even pass the Women's Health Act. So what's wrong with our democratic politics? I mean, something needs to be done. There needs to be some humongous reform. And you all in the San Ramon Valley Democratic Club, it's your job to try to see to it that we need. I hope that this wakes people up, but I'm afraid that it won't. I don't know what will. Yeah. Ellis Goldberg? Ellis and Sharon?
No, I think he just forgot to take it down his hand.
Oh, sorry. Okay. So I thought you had another question. And then we've got Cynthia.
Just a quick comment regarding the expanding the court. There are a lot of concerns that could have unintended consequences, but there's another proposal about having rotating justices, which sound fascinating to me, and I wonder your opinion on that.
Oh, I hadn't actually followed the rotating justices proposal. I think that there's a proposal for term limits, which actually, so I also study and teach comparative constitutional law. And by the way, our Supreme Court is the only one in the world that has life term.
You are recognized. Thank you, Mr. Speaker. I present AB.
Ooh. Somebody's got legislation in the background. Yes, so our Supreme Court is the only one in the world that has no term limits, no mandatory retirement. Basically, you're appointed for life, and it just can go on and on and on. These justices who are so young, they could last for a really, really long time. So there are proposals short of expanding the court, such as kind of creating term limits or having different presidents, each president. I think that's the proposal that you're referring to, Cynthia, having, every president kind of have a right to appoint a certain number of justices, as opposed to now when it's a bit random when a justice retires or when they die. And Trump, who didn't even win the popular vote, was able to appoint so many justices when Barack Obama, had so few. And of course, the horrible Mitch McConnell, who prevented that Merrick Garland, who was such a moderate. And then as soon as Justice Ruth Bader Ginsburg died, he turned around hypocritically and pushed through Amy Coney Barrett. So what can you do when Republicans play dirty and Democrats are too ethical and too weak?
Absolutely.
Well, Radhika, we just enjoyed your presentation so much. We learned a lot. Thank you so much for your time and coming here and speaking to our club. And
thank you for inviting me. And as I said, I'm honored to be part of such an eminent group. All of you for your wonderful questions and comments, and for all of you among your past speakers. You have such an eminent group of speakers that it's been a pleasure to speak with you. Thank you.
Thank you.
And I will cede my floor to our eminent assembly person. Thank you.
Yes, thank you. And I believe we're going to have Marilyn Lucey speak, and she'll tell us about Rebecca Bauer-Kahan, and she might even give us some information. So
yes, I will. Thank you so much, Dr. Rao. Thank you so much for sharing your knowledge. It was wonderful, and I learned so much just listening to you.
Thank you.
Hi, everybody. Assemblymember Rebecca Bauer-Kahan is still in session, if you can believe it. So she regrets that she's not able to be here personally, and she's asked that I provide the legislative update that she has promised. As some of you know, this is the last week in the Assembly to hear and vote on bills as a body. So bills that aren't able to be heard and voted on during this week will be done for the session. She has a lot of commitment to her bills, and she wants to also make sure that as many of her colleagues' bills can be heard and voted on. Yesterday, they voted on 220 bills. And so that's quite a long session. They're continuing the session. They are still in session at this time. If you know Assemblymember Bauer-Kahan, she is very proud to represent District 16 in the State Assembly. Thank you, Brody and Sangamon Valley Dems, for inviting her and allowing me to present on her behalf. She greatly appreciates the leadership and the advocacy that this club always provides in the East Bay. As Dr. Rao was marveling at the level of excellence in your speakers, we all know that your Democratic club always has the best speakers. So for those of you who may not know, Assemblymember Bauer-Kahan lives in Orinda with her husband and her 3 children. And prior to running for office, she was an environmental regulatory attorney and a law professor. And believe it or not, she didn't always want to practice law. She went to college thinking she was going to major in psychology and follow that career path. But it was an internship at a criminal justice center that sparked her interest in the law, and she began that path. So she considers it a true honor to fight for equity within our legal system. And like many of us, she was utterly shocked and scared when Trump became president in 2016. I see Nicole here. I know that, and I see Sheila Fish. Some of those 2 wonderful community leaders I met in that horrible, horrible time. So Assemblymember Bauer-Kahan was appalled when Trump instituted the Muslim travel ban, and she called Muslim agencies and said, how can I help? And they said, go to the airports and organize so that other attorneys can help you and make sure that these people who are coming into the country are not turned back. And they did. And they were able to make sure that every single person that had landed in SF was able to stay here. So it's very clear to her that so many of our hard fought for rights and progress were on the line then. And whether it was a woman's right to receive an abortion, the right for people to marry those who they love, or the right of people to live in a community that protects their cultural practices. Those are rights that she believes in and will fight for. Ever since the draft opinion on Roe versus Wade was leaked, activity has kicked into overdrive. She will tell you that while many were surprised, she was not. Many people working in the abortion space were not. She and others working in the abortion space knew this was coming, and we are lucky to have a pro-choice champion in our governor who had the foresight to create the California Future of Abortion Council. And it's made up of reproductive health care allies, partners, and leaders. In December last year, the council released 45 policy recommendations to prepare California for this eventuality. They saw it coming. The possible overturn of Roe v. Wade by the Supreme Court and the threats to our individual right to safe abortion care. If Roe is overturned, 26 states would immediately ban or severely restrict abortions. I think someone had mentioned that earlier. They knew that California would be the safe option for millions of women. We know that banning abortions does not decrease the number of abortions, but the number of medically safe abortions. And it's imperative that California leads the fight against extreme bans to this essential health service. For California to be a reproductive freedom state, we need to act on many fronts: education, legal, health care, etc., to protect the right to abortion care. Assemblymember Bauer-Kahan's bill, AB 166, and many bills from her Women's Caucus colleagues aim to put laws into place to shore up California's public policy protecting abortion patients and providers. This is in response to the challenges to what is already and still legal in our state of California: the right for people to exercise their choice whether or not to have an abortion. We know, and I think I heard this earlier as well, we know that white women with resources are already 4 times more likely to have a positive maternal health outcome than Black mothers. With essential abortion care threatened and women forced to carry unwanted or risky pregnancies, the disparity will increase even further. Financial costs are also a barrier to accessing essential abortion care, and there are a couple of bills by Assembly members' colleagues that are addressing that. Governor Newsom signed SB 245 into law in March of this year, which requires all healthcare plans to cover abortion services without a copay, deductible, or cost sharing. This bill was carried by Senator Lina Gonzalez and will make a huge difference for Californians. Assemblymember Weber's bill, AB 2134, provides grants to providers to overcome those financial barriers for low-income earners who need to access abortion and contraception care. Oops, sorry.
Moves a call.
I have to turn down the session. Finally, we need more providers. We need a robust system of providers to handle the need in California because this right is being banned in other states. Assemblymember Petrie Norris's bill, AB 1918, establishes the California Reproductive Health Service Corps to recruit, train, and retain a diverse workforce of reproductive healthcare professionals to work in underserved areas. So you see, good legislation is already at play. But the legislature and the California Future of Abortion Council cannot do this without the majority of Californians. Great Democratic clubs like San Ramon Valley Dems are always ready to help. And the question that comes to the Assembly member is often, what should people do to support this legislative work to protect abortion rights? You can educate yourself and others. You can donate, you can volunteer, and as I heard Nicole say, and you can vote. Educate yourself and those around you about what the overturn of Roe would mean. At its core, the question is not just about pregnancy termination. It is whether a woman will be treated as a citizen with full rights and privileges. And Dr. Rao went into beautiful depth on that possibility. People may not know what other rights are in jeopardy if Roe is overturned, but I think Dr. Rao did a fantastic job of really helping us to see that. You can donate and you can volunteer. Access Reproductive Justice is currently California's only abortion fund. They provide practical and logistical assistance to any Californian or person in California so they can access essential abortion care. Not every community has a provider to do abortions, and people sometimes have to travel hours or even days to get to a health center where they can get abortion care. Those expenses are a barrier, and access helps cover all of those costs or to coordinate logistics. Abortion issues disproportionately impact women, but not exclusively. Many of the states targeting abortion care are also passing laws that hurt trans people. Actively centering trans people in this fight is critical. They are often the ones most impacted and most forgotten. So get ready and organize, protest, and vote. Vote for candidates that are explicitly pro-abortion. Show up at rallies and marches, just as I heard earlier, to make sure that people see what our country stands for and that the overturn is not going to be supported. Find groups that are organizing these efforts and join them. There are many, many ways to help, and everyone can find something to do. You can help with voter registration. And all know, I saw Cecilia Manalga here, great vote organizer. Low voter turnout swings in favor of candidates who are not aligned with our values of reproductive freedom. Beyond voting for your state and your federal legislators, pay attention to the local races, because the races you think that have nothing to do with abortion rights ultimately will. At local offices, which are usually nonpartisan, a candidate can gain name recognition and a network and then run for higher office. So it doesn't matter what office, all the people you vote for should be explicitly pro-choice. School board members, city council board members, water board members, etc. Make that a litmus test for anyone you vote for. If you consider that during the pandemic, medication abortion became more common, and that would likely continue as a way to access abortion health services, our federal offices and state governorships come into play. So any of you who are volunteering for federal races across the nation to keep the majority in House and Senate and leadership at the state level, thank you. Because if these medications are provided over mail, then whoever's at the head of the Federal Postal Agency has a lot of power in that access chain for these medications. So educate yourselves like you are doing tonight, but also talk to your circle and educate them. And always continue to donate, volunteer, vote, and mobilize others to vote. In the middle of all this, the legislature does move forward, and it is seeking to meet its session deadlines. Thus, they are still in session trying to get through their docket of many bills. So budget priorities right now are still being negotiated, but the legislature hopes to tackle the ongoing COVID recovery, statewide drought, and record wildfires with the state's $97.5 billion surplus. As the chair of the Water, Parks, and Wildlife Committee, Assemblymember Bauer-Kahan was particularly excited to see that the governor proposed $1.3 billion in investment for immediate drought response, which includes aiding residents, farmers, and wildlife as we continue to grapple with this statewide issue. As an advocate for reproductive rights, actually a champion, and the chair of the Select Committee on Reproductive Health, she's thrilled to see that there will be $125 million invested in reproductive health care. As discussed earlier with the recently leaked draft opinion, the right to abortion is under threat. So California continues to fight for access, and our RBK is leader in that. Increasing accessibility and availability of healthcare services is exactly what California needs in light of extremist threats and attacks. No one should ever feel fear for simply exercising their rights. RBK hopes to negotiate additional funding this year for our state's 988 system. For those who may be unfamiliar, 988 creates an alternative to 911 with an easy 3-digit phone number for immediate non-police response for individuals in a mental health crisis. 1 in 6 Californians live with a mental illness, but only a third receive treatment. Over the past 2 decades, suicides have increased by 35% across the country. As many as 1/3 of the 160,000 individuals who are living on the streets in California have a mental health condition. California and all other states were granted an opportunity when Congress and the FCC created the 988 Suicide Prevention and Mental Health Crisis Hotline. We are less than 100 days away from the launch of 988 on July 1st, and California is not ready. Without a clear framework, we run the risk of this opportunity getting lost to California bureaucracy. And that's why she crafted AB 988 to work on a framework for a well-funded mental health crisis response system. While the legislation did not completely cross the finish line last year, we did have an important victory by securing $20 million in funding to get the 988 crisis line up and running when it goes live this July. But that funding will only pay for the resources to run call centers for the first year. We continue to work on AB 988 this year to lay out a clear framework and funding to implement 988, ensure effective mental health crisis response across the state, and add accountability to make sure that people don't fall through the cracks. With this legislation, we intend to create a model for refocusing and decriminalizing our mental health crisis response system, creating the same type of health-based response to mental health crises that we use for other health emergencies. This year, she introduced a number of bills that address some top priorities: gender equality, wildfire protection, education, gun safety, environmental protection, and more. I spoke about AB 166, reproductive rights, a little bit earlier, and she is very proud of this bill this year. This bill would protect all those who could be sued as defendants in actions involving reproductive rights here in California and declare it to be against the policy of the state to infringe upon an individual's reproductive health choices. Across the nation, the right to abortion has been consistently under threat, as groups have blocked access to health centers such as Planned Parenthood. We've witnessed that ourselves here. The right to abortion is enshrined in California's very own Constitution, and we must continue to protect our state's reproductive freedoms. Last year, the legislature passed AB 439, ensuring that non-binary individuals are identified as such on their death certificate. This year, she introduced something similar, AB 2436. This bill would update forms that are used to generate death certificates by removing mother and father and instead replacing them with parent 1 and parent 2. Today, families are diverse. Maybe they've always been and we haven't noticed it. But children today can have a mom and a dad, 2 moms or 2 dads, or non-binary parents. Every family in California deserves to be represented and correctly identified to reflect who they are. Her work is continuing on AB 1287, which she introduced last year. This bill eliminates the pink tax, an unfair burden that results when women's items are arbitrarily priced differently than the identical items that are marketed to men. Another bill, AB 2282, seeks to strengthen and equalize penalties for using symbols of terror. Right now, current law recognizes the swastika, the noose, and the desecrated cross as symbols of terror. But the penalties for each of these terror symbols is different. If passed, this bill would make the criminal penalties the same for each. It would also make the locations that the crime can be applied to the same, including K-12 schools, colleges, cemeteries, places of worship, places of employment, private property, public parks, public spaces, and public facilities. While communities and local organizations have banded together to push back against hate, we need to take action at the state level. Another issue that has been brought to her attention by constituents is the substandard care that is apparent in many skilled nursing facilities throughout California. AB 1907 would align state and federal nursing home inspection timelines for inspections by allowing a state inspector to do one inspection that fulfills the requirement for both state and federal government at the same time. When these inspections are aligned, resources become more readily available, which in turn allows for more inspections of the nursing facilities to protect residents. All too often, our staff receives complaints of abuse and neglect from constituents that they themselves or a loved one has faced while residing in nursing facilities. And it breaks our Assembly members' heart to think that some of our most vulnerable residents are not receiving the level of care that they deserve. As chair of the Water Parks and Wildlife Committee, protecting our environment and those who may be impacted by environmental harms is one of RBK's top priorities as we continue to face the impacts of climate change. In 2021, it was California's worst fire season in recent memory. Over 10,000 wildfires had burned over 4.2 million acres, and that's approximately 4% of all the land in the state of California. Climate change has made our fire seasons longer, more unpredictable, and more intense. At this point, it's fair to say that wildfires are now a way of life in California. So RBK's bill, AB 2070, would require utility companies to provide clear communication and notify local fire districts before any fire safety or mitigation services in a high fire risk area. Private utility companies are in charge of managing vegetation and repairing their facilities in order to prevent future fires. However, much of their work is done in high fire areas close to residential neighborhoods and local businesses, putting them at risk. And actually, when I was waiting for my turn to make a report, that bill passed the Assembly. AB 2146 is part of her ongoing efforts to save the bees. This bill would ban the use of the top 5 neonicotinoids on non-agricultural crops to protect bees and other pollinators. While doing background research on this bill, we found out that California beekeepers lost over 40% of their colonies last year, one of the worst years on record. There is a huge body of research that links adverse health impacts and the decline in pollinator populations to the use of pesticides, particularly neonicotinoids. Just 1 square foot of grass treated with neonicotinoid lawn product can contain enough neonicotinoids to kill 1 million bees. And that is a gigantic loss for California's ecosystems and the agricultural crops that rely on pollinators. The European Union has already banned many of these pesticides, and it's time that California catches up with the rest of the world. Even before the recent tragedies, as a mother of 3, gun safety has continually been on top of mind for her. And she is a Moms Demand volunteer previously and a supporter. We need to do our best to keep our kids safe, which is why she introduced AB 2571, which restricts the advertising of firearms that are aimed towards children. Although children are not allowed to own firearms, they are targeted with advertising that encourages them to own and use these dangerous weapons, which all too often result in accidental shootings and deaths. Firearm companies have taken to use social media as an advertising platform, whether it be through YouTube, Twitter, or influencers, all of which children have easy access to. And this is dangerous and this is wrong. She also has a number of other bills that she's introduced thus far, and creating equitable research-backed legislation is RBK's main goal as an Assembly member. She's proud of the bills and the budget wins she's helped to pass on behalf of 16 constituents in the state of California, and she's eager to see what the rest of the year will bring for the legislation she's introduced and has passed the Assembly, and they're on their way to the Senate. If you're interested in reading more about the bill package, there is more information available on our website. Our team in Sacramento and the district office in San Ramon have been extremely busy making sure that our constituents' needs are met. Whether it's meeting with constituents to talk about their bill proposals, hosting town halls to disperse vital information, or recording videos on pertinent topics, Team RBK works tirelessly to address the needs of her district. Again, thank you again for inviting Assemblymember Rebecca Bauer-Kahan to speak and for allowing me to make a report on her behalf. Our door is always open and we look forward to continuing our important work together. So if you have any questions, please do not hesitate to call our office at 925-244-1600 or use the contact form on the AD16 website. And we would be happy to meet with you and communicate with you. Thank you, Brody.
Marilyn, that was very extensive. Thank you so much.
You're welcome.
Wonderful. Yeah. Thank you so much for being here. Do we have any questions for Marilyn? Oh, Ellis?
Sharon just said I always have a question. It's not really a question. It's a slight embellishment, and it's we can't be telling voters who asks us why to vote for Rebecca Bauer-Kahan 100 different bills that she's worked on. but there's a simple story. Rebecca's grandmother was in Austria during World War II and wrote to somebody in New York asking them to sponsor her family to come to America. That person responded, and as a consequence, the letter has been part of the family history that she told me the first day I met her. Rebecca did. And the reason I bring this up is that when the Muslim ban came down that Marilyn spoke of, Rebecca went to the airport, to San Francisco Airport, with a contingent of ACLU lawyers to meet the Muslims who were in flight when the Muslim ban came down. And at one point, they were praying in a lobby, and TSA was coming down the hall. And Rebecca got up on a bench, and Rebecca's not all that big, as many of you know, and said, "Hold off. This is the United States. We have freedom of religion here. Let them finish." And she held off TSA. She later called up her grandmother and told her what had happened. And you know what Grandma said? "Not enough." And that's why Rebecca ran for the assembly. And that's why she does all of the things that Marilyn spoke about. So if you're going to tell somebody why they should vote for Rebecca, yeah, there are dozens of bills and like that. But this story tells about where her heart is and where her energy comes from and why you should trust her. I trust her. I wear a hat. Anyway, my 2 cents. And thank you, Marilyn. That was an excellent presentation.
Very nice, Ellis. Is there any more questions? Well, we've had a very, very long, informative night. Thank you so much. Remember, we have our 4th of July parade in July. I hope you all will participate. We'll probably be with, if we can, with Moms Demand Action and Rebecca Bauer-Kahan, who are walking. We'll see how that goes. And so thank you so much for being here. I look forward to seeing you next month.
Thanks, Brody.
Thanks, Brody. Thanks, everyone.
Oh, Cynthia, thank you for being here. Yeah, had some good comments.
Thank you.
Bye-bye.
Thanks, Brody. Great meeting.
Thank you.
Yeah, thanks, everybody.
Thanks, Joanne.
Thank you, Brody.
Oh,
That was a
Terry,
great,
you could join us.
that was a great meeting. Thank you. I appreciate your call.
Thank you, Terry.
And Brody, I'll trade you bridges.
You're what?
I'll trade you bridges. We both got the same bridge.
Oh, right, yeah. Yours is going the wrong way, though. Mine's. And thank you, Cecilia and Rick, for being
Yeah.
here and helping.
Cecilia doesn't get enough credit.
Oh, I know. Cecilia's amazing.
I'm happy to stay in the background. So that was absolutely fabulous. That's one of the best speakers I've heard
I agree.
ever.
Yeah.
She was top notch.
Yep.
So I'll see you guys.
Okay. Keep up the
Bye.
good work.
Good
Bye-bye.
morning, everyone.
Have a good Memorial Day.
You too.
Thank you.
Ross, I'm glad you were able to join us. I guess he's not there.